The report of the Independent Human Rights Act Review and Government Consultation. On the 14th of December 2021, the government published an independent report on the Human Rights Act written by the panel of the Independent Human Rights Act Review, and a consultation paper called Human Rights Act Reform, a Modern Bill of Rights. The report summarises the panel's finding and looks at how the Human Rights Act works in practice, who it protects and how it is used, and makes suggestions of how it should work in the future. The government's consultation sets out wide-ranging plans to replace our Human Rights Act with a Bill of Rights. This goes much further than the IHRAR recommended. The Human Rights Act is the UK law that exists to ensure everyone's rights are respected and protected. It contains 16 rights, including the right to life, the right to respect for family life, the right to liberty, and the right to be free from discrimination. It puts a legal duty on public bodies to respect, protect, and fulfil our rights. It also puts limits on the power of the government and public bodies. The government is not saying they want to change the rights, rather how these rights can be enforced. The IHRAR was announced in December 2020, set up by the UK Ministry of Justice as an independent panel. It put out a call for evidence asking about the relationship between domestic courts here in the UK and the European Court of Human Rights, and the impact the Human Rights Act has had on the relationships between the judiciary, the government and Parliament. BIHR worked with over 400 people in our submission to the IHRAR. We wanted to make sure the panel heard directly from people who have relied on the Human Rights Act to help them challenge poor practices without going to court. The IHRAR received over 150 responses and met with different groups of people. The report said, "The effectiveness of the Human Rights Act cannot just be measured in the courtroom. There needs to be more education on the Human Rights Act to increase public ownership. There needs to be more transparency in how the Human Rights Act works. And the vast majority of submissions received by the IHRAR spoke strongly in favour of the Human Rights Act." At the same time as publishing the IHRAR's report, the government also announced plans to overhaul the Human Rights Act. The timing is challenging because the IHRAR report was not available before the government's consultation proposals. The government's consultation suggests that the Human Rights Act should be replaced with a Bill of Rights. It is not asking people whether this is a good idea or not. The consultation looks at 5 key areas: respecting our common law traditions and strengthening the role of the UK Supreme Court, restoring a sharper focus on protecting fundamental rights, preventing the incremental expansion of rights without democratic oversight, introducing responsibilities within the human rights framework, and facilitating dialogue with Strasbourg while guaranteeing Parliament and the devolved legislatures their proper roles. Respecting our common law traditions and strengthening the role of the UK Supreme Court. According to Section 2 of the Human Rights Act, all courts in the UK must take into account any relevant cases decided by the European Court of Human Rights. The government suggests UK courts should instead just look at the text of the right themselves and at decisions previously made in the UK. People will still be able to take cases to the European Court of Human Rights for a decision there. This could mean more cases being taken to and decided by the European Court of Human Rights. The consultation also suggests that the Bill of Rights should contain a provision that highlights the importance of the right to freedom of expression. This right is already contained in the Human Rights Act. It is protected by Article 10. Like most rights, the right to freedom of expression must be balanced against other rights. The government wants to set out guidelines on how this right should be balanced, and that it should only be limited in exceptional circumstances. Currently, any non-absolute right can only be limited if the measure is lawful, legitimate, and proportionate. Restoring a sharper focus on protecting fundamental rights. The consultation suggests requiring people to demonstrate they have suffered a significant disadvantage for their case to be heard at court. It also suggests that human rights should only be used if there are no other claims that can be made. This would reduce the number of human rights cases heard in our court. Already under the Human Rights Act, legal action can only be taken if the individual is the victim of a human rights breach. Preventing the incremental expansion of rights without democratic oversight. Under Section 3 of the Human Rights Act, any laws in the UK must be read in a way which is compatible with the European Convention on Human Rights. If a non-absolute right must be restricted, that restriction must be proportionate or the least restrictive. The consultation proposes that Section 3 should be replaced with a provision which sets out how legislation should be interpreted. They want to place further weight on the view of Parliament. This may reduce the importance of proportionality. The consultation also suggests that the use of human rights law by foreign criminals who are going to be deported should be restricted. The government used an example from a decision in 2009 to justify this, but there was a significant change in the law in 2014, which means this situation should no longer occur. The Human Rights Act does not prevent such deportations, as they're still taking place. Changing any of the rights due to a concern in one area will likely impact those rights in other areas. For example, the right to family life helped people keep contact with loved ones in care homes during COVID. Emphasising the role of responsibilities within the human rights framework. Human rights are universal. This means that they apply to everyone. The consultation suggests introducing responsibilities into the human rights framework. This could mean an individual's behaviour could be considered when deciding whether it was acceptable to limit their rights. It also suggests an individual's behaviour should be relevant when deciding on any remedies they may be entitled to for a breach of their human rights. This may mean that not everyone is entitled to the same rights. Facilitating consideration of and dialogue with Strasbourg while guaranteeing Parliament its proper role. The consultation suggests that Parliament should have a stronger role in responding to the European Court on Human Rights. Currently, Parliament can decide whether they do or don't change the law in response to a judgment. For example, a decade after an IHRAR ruling on prisoner voting, a small number in the UK were allowed to vote. This brought the UK in line with the decision without a large change in the law. So, what next? The law has not changed, and the proposals in the consultation paper are not final. In March 2021, the consultation will end. It's important that as many people as possible respond to the consultation so that their voices are heard before any decisions are made about their rights. To find out how BIHR is going to respond and how you can get involved, go to bihr.org.uk/human-rights-act-reform.